This is the final session of the second weekend on torts, and we're going to try and have a 1 hour session where we learn a lot about torts and people feel what it's like to have individualized attention as they're studying. So we're going to start with the first question, and Alita, you're on the mic. It's up to you. Do you want me to read or you to read?
I'll read it.
Okay.
Will the governor prevail? The governor of a state signed a death warrant for a convicted murderer. Two protesters are active opponents of the death penalty. At a demonstration protesting the execution of the murderer, the protesters carried large signs that state, "The governor, murderer." A television station broadcast news coverage of the demonstration, including pictures of the signs carried by the protesters. The governor asserted a defamation claim against the television station. Assume that the jury finds that although the signs caused the public to hold the governor in lower esteem, the only reasonable interpretation of the signs was that the term murderer was intended as a characterization of anyone who would sign a death warrant. Will the governor prevail? Yes, because the signs would cause persons to hold the governor in lower esteem. Yes, because the governor can prove that the television station showed the signs with knowledge of falsity or reckless disregard of the truth that the governor had not committed homicide. No, because the governor cannot prove he suffered pecuniary loss resulting from harm to his reputation proximately caused by the defendant's signs. No, because the only reasonable interpretation of the signs was that the term murderer was intended as a characterization of one who would sign a death warrant.
So what are your thoughts, Alita? Which ones can we eliminate? Let's start with process of elimination.
Well, I tend to reread the question sometimes just because
Reread it.
truth be told, when I read out loud, it doesn't process as well for me.
Reread it to yourself.
Okay, I think it's gonna be no, he's not gonna prevail, so I would eliminate A and B.
I'm with you. This isn't, don't feel on the spot. You can ask me for my
Then I would say C. Just because, well, a defamation claim, like especially for the governor who's like a public figure, it would have had to been with like malice, and they're not, the TV isn't broadcasting something that they're saying is true or false.
Can I give you an interpretation I have from this question? One is governor murderer. Well, that sounds like per se, because he's a murderer and that's a crime of moral turpitude. But then I believe that truth is a defense to defamation. And they do say here that the only reasonable interpretation is that by calling him a murderer, it's because he signed a death warrant. Therefore, he is a murderer under the reasonable interpretation of the sign, right?
Yeah.
I like D. Anyone in the room agree with D?
I like D.
I like D too.
Yeah, D is a better answer there. Because the statement could be reasonably interpreted only in one way, then that interpretation must be, in fact, be defamatory in order for plaintiff to prevail in a case of defamation. Here, the statement was that murderer means that what would sign a death warrant. Therefore, the statement was the expression of an opinion not based on specific facts and would not support a defamation action. As a public figure, he would need to show that the television acted reckless with falsity. Under the facts presented, the claim would fail. Therefore, he would only need, there was any need for him to prove the standard. However, one finding by the jury was that although the sign caused the public to hold the governor in lower esteem, the only reasonable interpretation was that the term murder was intended as a characterization of anyone who would sign a death warrant. To this end, while the signs were clearly defamatory, they were only statements of negative opinion. Consequently, there were no false statements of fact at issue. The governor's defamation claim would fail at the outset. Right, I did want to say, they did talk about this. There we go. I was like, I knew they were going to mention it. Murderer would qualify as slander per se, right? Or libel per se, whatever it may have been, because it's a crime of moral turpitude. So we were on top of that. Excellent job. You're good with that, Alita? The key there was that truth is a complete defense. So I like that. All right. Do you mind stepping up to the plate on the microphone?
Sure. Do you want me to read it or are you going to read it?
Totally up to you. You have preference. I treat
Read
all
it?
my client students with white gloves.
I'll let you read it, Andrew.
Okay, thank you. Does the homeowner have a viable claim against the manufacturer of the snowblower for damages? A homeowner was injured when an automatic cutoff switch failed to function on a snowblower he was using. The cutoff switch had functioned well for a year after he purchased a snowblower, but failed after the machine had been improperly repaired by a mechanic. What does that sound like? Improperly repaired by a mechanic?
Well, I would say it cuts off the...
Some sort of intervening or supervening.
Right.
Okay. The snowblower's operating manual contained a clear and prominent warning against making the very alteration to the switch mechanism that was made by the mechanic. So that statement's important because it's like the snowblower's trying to prevent against this idiot mechanic doing what he did. The mechanic, however, did not have a manual available when he repaired the snowblower. Does the homeowner have a viable claim against the manufacturer of the snowblower for damages? Do we tend to think he does or he doesn't here? The homeowner against the manufacturer.
Wait, I'm going to read the choices.
Okay.
No, against the snowblower. Okay. No, because the injury resulted from a substantial... I would say B.
I like B here too. I think this was substantial enough to completely cut off liability. They told you in the manual not to do this. This dude improperly did this, or this lady. I think this mechanic is at fault. Does everyone in the audience like B?
I like B too.
B as in basketball. All right, good job, Pablo. I see you said B too. Yeah, we got to understand, where does it cut off liability? The plaintiff must show it was defective when it left the defendant's control. The alteration was clearly warned against. It's an intervening cause that occurs after the initial act and cuts off liability. The Mechanics Act can be said to be intervening and they will not be liable. Extended explanation. There was a change which the snowblower's manual expressly warned against. They substantially altered it by a third party. They would not be able to recover. Good job. All right, Grace, you want to read this one for us? Or let's talk about it. Do you want me to read it or do you want to read it?
Yeah, you can read it.
Okay. Which of the following conclusions would best support a claim by the woman against the debt collector for intentional infliction of emotional distress? A wealthy elderly woman was repeatedly harassed by a debt collector. Sorry, someone said in the chat. Oh, you're putting me to work. Yeah. Sorry. I like reading, actually. I like to read. Okay. Which of the following conclusions would best support a claim by the woman against the debt collector for IED? A wealthy elderly woman was repeatedly harassed by a debt collector over a period of 2 months. The debt collector was trying to collect a large debt owed to his client by the woman's impoverished adult son. Although the debt collector knew that the woman was not legally responsible for the son's debt, he called the woman multiple times each day and threatened to destroy her credit. He also told her that he knew where she lived and that he was going to withdraw the money from her bank account. As a result, the woman suffered great mental anguish, was unable to sleep, and ultimately suffered serious health consequences. That seems like physical. Which of the following conclusions would best support a claim by the woman against the debt collector for an IIED? All right, Grace, you can read the answers and kind of tell me what your thoughts are.
A, because she suffered the physical.
What about D? extreme and outrageous. Don't we like that language?
See, that's why I always jump to conclusions.
It's not, no, A is not a bad answer, but I like D as well.
Yeah.
Because that's the language for IIED. And if you can establish that conduct, that should be good. Whether it's foreseeable that they might cause
That's
harm.
negligence.
Yes, indeed. We like D as in dog?
Yes.
All right, good. And again, it's all about the process of learning and remembering things. We're going to remember now that IIED, extreme and outrageous. And of course, always read through the questions first. But I mean, read through the answers first. But yeah, this would be extreme and outrageous. That's the best cause of action here. That's the best language to support a cause of action. Cool. Let's see. Joe, do you mind reading this question, or do you want me to read it? Whatever you like.
I can do it. It's fine.
Thank you.
If the actor sues the vineyard to recover damages as a result of the vineyard's use of the photograph, will the actor prevail? A well-known movie star was drinking vineyard wine at a nightclub. A bottle of the vineyard wine, with its label plainly showing, was on the table in front of the actor. An amateur photographer asked the actor if he could take his picture, and the actor said yes. Subsequently, the photographer sold the photo to the vineyard, Vineyard, without the actor's consent, used the photo in a wine advertisement in a nationally circulated magazine. The caption below the photo stated that the actor enjoys his vineyard wine. If the actor sues to recover damages as a result of Vineyard's use of the photograph, will the actor prevail? A, no, because the actor consented to being photographed. B, no, because the actor is a public figure. C, yes, because the vineyard made commercial use of the photograph. D, yes, unless the actor did, in fact, enjoy his vineyard wine.
¿Qué piensas?
So I think off the bat, I think it is yes as the conclusion. So I would eliminate A and B. D seems kind of, I don't know, like not a very good explanation. So I guess I would go C.
Not bad. I'm cool with that. That's a good way to arrive at the right answer. It's kind of like the taste test. You tasted A, B, and D, and they all tasted yucky. C tastes pretty good, right? I'm not gonna argue with that line of reasoning. On the MBE, when you're taking it, you don't always need to know why you're doing everything you do, as long as it's just like natural. That was very natural, but the true reason is because it's commercial use. If they use commercially their photograph, then that would be some sort of appropriation, right? Everyone cool with why that was appropriation and why that was the most important thing? He didn't consent to it, and they used it in a commercial way. Commercial appropriation of the actor's likeness for Vineyard's benefit is subject to damages and claim for invasion of privacy. The actor, well-known movie star, has a property right in his name and likeness. Vineyard cannot use a photograph without being granted a license to do so by the actor. Okay, cool. The actor will recover. He's permitted to take the picture for personal use. He did not consent for advertisements to unlicensed image for commercial purposes. He'll be able to recover him for invasion of privacy claim. Solid. I'm liking the length of these questions now. May, do you mind reading this question, or I can read it, whatever you prefer?
I can read it.
Thank you.
Should the court grant the store's motion? A mother purchased an expensive television from an appliance store for her adult son. 2 years after the purchase, a fire started in the son's living room in the middle of the night. The fire department concluded that the fire had started in the television. No other facts are known. The son sued the appliance store for negligence. The store has moved for summary judgment. Should the court grant the store's motion? No, because televisions do not catch fire in the absence of negligence. No, because the store sold the television. Yes, because the son is not in privity with the store. Yes, because there is no evidence of negligence on the part of the store. I think I would go, or I like D. I guess I'm kind of between A and D.
I'm with you, and I think it's D.
I'm leaning more towards D because it seems like a products liability thing or claim, and it says that this happened 2 years after the purchase, so something he could have done something to the TV in that time.
Right. A is a trap answer. It's not res ipsa. It was not in their exclusive control. You had it for 2 years. I like D. Yeah. Right. It's not res ipsa because the son is suing in negligence, not strict liability. To make a prima case for negligence, he must introduce evidence that the store is negligent. The son is not pointing to any negligent action or omission. It's not appropriate for res ipsa because the manufacturer rather than the store may have been negligent, or the negligence may have occurred after the sale during repair while the television was being used by the son. Even if it were true that televisions do not catch fire in the absence of negligence, the fact that this television did is insufficient to establish that the store acted negligently. This is not an appropriate case for res ipsa because the manufacturer rather than the store may have been negligent, or the negligence may have occurred after the sale. Because the son cannot establish the store's negligence, they should not grant the store's motion. That's a tough question. I think A is an appealing answer. Yes, you picked A in the past, but the answer is D there because it was a negligence claim, not a strict liability claim. Good job. Let's see. Pablo, do you mind reading this question?
Yes. The driver was traveling along a highway during an unusual heavy rainstorm when the roadway began to flood. To protect his car from the water damage, the driver pulled his car up to a step on a market driveway, a building at the highway that led to the homeowner residence. The driver left his car parked in the driveway and walked home, intending to return when the flood water had subsided. Shortly after the driver started to walk home, the homeowner carefully rolled the car back down his driveway and parked into the highway shoulder. The flood water continued to rise and caused damage to the driver's car. If the driver sues the homeowner to recover for damage to the car, is the driver likely to prevail? A, yes, because the driver was privileged to park his car on the homeowner property. Yes, because there were not trespassing sign posted. No, because the driver intentionally drove his car onto the homeowner property. No, because the owner was privileged to remove the car from his property. Here we can eliminate C and D because it's yes for sure. Because it's a storm ongoing, the best answer is yes, because the driver was privileged to park his car onto the homeowner property. Yes.
It's like clockwork, right? It was privileged and you pushed him away, and you shouldn't have done that. You know, he had a privilege and you violated that by pushing him away. Very good job. This is good. You know, again, that's why I like getting questions wrong. We're not really learning too much right now, but we're reinforcing, and hopefully people out there are, you know, there was some at the beginning that were tougher, but so far so good. Okay, and then last but certainly not least, Sam, do you mind reading this question?
Sure, I'll read it. If at the conclusion of the evidence both parties move for directed verdicts, how should the trial judge rule? A consumer bought a kitchen blender from the manufacturer. Soon after the purchase, the consumer was using the blender in an appropriate way when the blender jar shattered, throwing a piece of glass into the consumer's eye. The consumer brought an action against the manufacturer based solely on strict products liability. The consumer's expert testified that the blender was defectively designed. However, because the blender jar had been destroyed in the accident, the expert could not determine whether the accident had been caused by the design defect or a manufacturing defect. The manufacturer's expert testified that the blender was not defective. If at the conclusion of the evidence both parties move for directed verdicts, how should the trial judge rule? A, direct a verdict for the manufacturer because the consumer's expert was unable to specify the nature of the defect. B, direct a verdict for the manufacturer because the consumer's action was brought solely on a strict liability theory. C, direct a verdict for the consumer because the blender was new when the jar shattered and thus was undeniably defective. D, deny both motions and send the case to the jury because a jury reasonably could conclude that the harm was caused by a defect present in the product when it was sold. whenever I get these motion for directed verdicts, I always go for deny both motions, generally, because usually it's not 100% clear. Usually it's always something for the jury to try to figure out. And I guess here they're trying to figure out if there was actually a design defect, or if there wasn't, because the manufacturer expert testified that the blender was not defective.
Funny. Not funny, weird. Not funny, haha. Funny, weird.
Yeah, I think I'm gonna stick to D.
I like D too. Anyone in the audience have any thoughts? We're seeing some D's. Throw those D's up. Oh no, that's where I'm gonna get it wrong. Hooray. A jury could conclude that the blender was defective at the time of sale because the accident is the sort of accident that ordinarily occurs as a result of a defect and no other cause was identified. But the jury is not required to draw that conclusion. So you're right on it, Sam. Like, let the jury decide. To recover, they must prove that the defect existed when it left the defendant's control. A reasonable jury could determine that the blender was defective at the time of the sale because the accident which occurred is a sort of accident that ordinarily occurs as a result of a defect and no other cause was identified, although it is not required to do so. In addition, a reasonable jury could also believe that the manufacturer's expert's conclusions that the blender was not defective, but again, it would not be required to do so. Therefore, the judge should deny both parties' motions for directed verdict because a reasonable jury could, but is not obligated to, believe the other party. Everyone good on that? All right. Back to the top of the order. Alita, do you want to read this one or do you want me to read it?
I'll read it. In a negligence action by the man against the car rental agency, is the man likely to prevail? A man rented a car from a car rental agency. Unbeknownst to the rental agency, the car had a bomb hidden in it at the time of the rental. The bomb exploded an hour later, injuring the man. Immediately prior to renting the car to the man, the rental agency had carefully inspected the car to be sure it was in sound operating condition. The rental agency did not inspect for hidden explosive devices, but such an inspection would have revealed the bomb. There had been no previous incidents of persons hiding bombs in rental cars. In a negligence action by the man against the car rental agency, is the man likely to prevail? No, because the rental agency could not have reasonably foreseen the likelihood of someone placing a bomb in the car it was about to rent to the man. No, because the rental agency did not hide the bomb in the car. Yes, because an inspection for explosive devices would have revealed the bomb. Yes, because the bomb made the car abnormally dangerous. I would eliminate D, first of all. I would say A, and I would eliminate B. Yeah. I would just say A.
Yeah, again, some A's in the chat. And yeah, like, you weren't supposed to find a bomb. That's crazy. Someone else put the bomb in there, and you carefully inspected it. So I like A. Good job. The standard to be applied in negligence action is where a defendant acted with ordinary care. The presence of the bomb in a rental car is sufficiently unlikely that a reasonable rental car agency would not routinely expect for such a device. In the absence of evidence that the agency should have foreseen that there might have been a bomb hit in the car, the man cannot prove a negligence claim. All right. Let's see. M, do you mind reading this question, or I'm happy to read it, whatever you prefer?
Up to you. Dealer's choice.
All right, you read.
Okay. A plaintiff and a defendant were in the habit of playing practical jokes on each other on their respective birthdays. On the plaintiff's birthday, the defendant sent the plaintiff a cake containing an ingredient that he knew had in the past made a plaintiff very ill. After the plaintiff had eaten a piece of the cake, he suffered severe stomach pains and had to be taken to the hospital by ambulance. On the way to the hospital, the paramedic who was driving the ambulance suffered a heart attack, which caused the ambulance to swerve from the road and hit a tree. This is all foreseeable. As a result of the collision, the plaintiff suffered a broken leg. In a suit by the plaintiff against the defendant to recover damages for the plaintiff's broken leg, the plaintiff will prevail because the defendant knew that the cake would be harmful or offensive to the plaintiff. B, not prevail because the paramedic was not negligent. C, not prevail because the defendant could not reasonably be expected to foresee injury to the plaintiff's leg. Or D, not prevail because the paramedic's heart attack was a superseding cause. It's going to be A. He's going to prevail. It's all foreseeable. It's not superseding.
They're just trying to get you to think it's not foreseeable, but all this stuff is foreseeable, as you said, as you navigate the question.
Yeah.
Yeah. Definitely foreseeable. The defendant intentionally fed the plaintiff a substance that he knew would make the plaintiff very ill. Despite the red herring statement that the two were in the habit of playing practical jokes, this is battery. A battery is caused by intentional or harmful offensive contact to the plaintiff's person or an extension thereof without consent or privilege. The actual touching need not be done personally by the defendant as long as the defendant set into motion action with purpose or knowledge to a substantial certainty that the offensive or harmful touching would result. Right? Like, all this stuff was foreseeable. All right, Grace, you mind reading this question?
A host pointed an unloaded revolver at her guest, threatening to shoot him. The guest knew that the revolver was not loaded and that the ammunition for the revolver was stored in a locked basement closet, 2 stories below where the two were then standing. In an action brought by the guest against the host for assault, will the guest prevail? No, pardon. Will the guest be likely to prevail? No, because the host did not intend to shoot her guest. No, because the host did not put her guest in apprehension of an imminent contact. Just because the ammunition was accessible to the host. Just because the host threatened her guest with a revolver. I think it's B, as in boy.
Right, because they knew that it was not loaded, so there was no reasonable apprehension of imminent contact. We're getting to that point where torts are getting nice and easy. The tort of assault requires that the plaintiff have an apprehension of imminent bodily contact. The result did not occur here because the guest knew that the revolver was not loaded and the ammunition was in a locked basement closet. Everyone's cool with that? Alita, good job. I see you put that in the answer. Nice. I love short questions. My favorite. Joe, do you mind reading this one?
Yep. If the farmer brings an action against the chemical company to recover the value of the cows that died, the farmer will. A chemical company manufactured a liquid chemical product known as XRX. Some XRX leaked from a storage tank on the chemical company's property, seeped into the groundwater, flowed to a farmer's adjacent property, and polluted the farmer's well. Several of the farmer's cows drank the polluted well water and died. The farmer brings an action against the chemical company to recover the value of the cows that died. The farmer will A, prevail because the manufacturer is strictly liable for harm caused by its products. B, prevail because the XRX escaped from the chemical company's premises. C, not prevail because the farmer is not a foreseeable plaintiff. D, not prevail because the chemical company was not engaged in an abnormally dangerous activity. I think it'll be either A or B. I would think the farmer would prevail in this action. I don't know if there's any, I just think chemicals in general going into water is usually pretty bad. So I guess I would lean A, and that would be held them strictly liable. I don't think just escaping from, I don't know. I'm not sure though.
I don't like for harm caused by its products because it's not any harm. It's harm caused by the dangerous propensities, of its products. Here, I think we have a lot of A's in the gallery. Strictly liable for harm caused by its products versus Prevail because the extract escaped from the chemical company's premises.
I don't think just escaping from the premises is why, they would prevail on an action. It's because they killed the cows and got in the water. I guess that's my reasoning.
Can I chime in a little bit?
Chime away.
I was gonna say, because the facts did tell us that they polluted the cows, so that satisfies the toxicity, the damage because of toxicity, and the way that they did receive the toxic chemicals was because it escaped from the company's premises. Like Andrew said, they cannot be strictly liable. That means for any harm, because it's not any harm. It's only harm from the toxicity of the chemicals. So I think it is B.
Any rebuttal?
But it is kind of tough.
I'm with you. I'm on your side, Sam, honestly. But they like A.
It seems too all encompassing for me.
Yeah, I don't like the harm caused by its products.
Right.
A is incorrect as far too broad. Simple as that. Too broad, right? All, always, must. Not because they're negligent in abnormally dangerous activity, because of the company's engagement in abnormally dangerous activity, not due to product liability. A company will only be strictly liable for harm caused by its product if certain conditions exist, namely an evidentiary showing that the product itself was unreasonably dangerous or defective. The firm will prevail under strict liability theory, but because of the company's engagement in normally dangerous activity, not product liability. A manufacturer is strictly liable for harm, right? If they would have said because it's an abnormally dangerous activity, but yeah, we see that A is totally wrong. A was trying to make this a products liability answer when it was an abnormally dangerous. So if it was going to be strictly liable, it wouldn't have been the manufacturer by its products. It would have been a, partaker in abnormally dangerous activities is strictly liable, right? Do we see that why B is now a better answer? B.
Yes.
Strict liability question based on abnormally dangerous activity. To sustain this cause of action, they must prove that the nature of the activity imposed an absolute duty on the company to make it safe, and the damages were caused by the defendant's failure to do so, and the damages occur. They had an absolute duty to make it safe. It's a toxic chemical. The only other necessary showing is the leak, the chemical that kills the cows, escaped from the premises. So B was kind of assuming that it was a abnormally dangerous activity, and we just had to prove this element. A was trying to make you prove products liability, which would not have been correct. So good job, good learning question. May, do you mind reading this one?
While walking on a public sidewalk, a pedestrian was struck by a piece of lumber that fell from the roof of a homeowner's house. The homeowner had hired the repairman to make repairs to his roof, and the lumber fell through due to negligence on the repairman's part. Assume that the homeowner exercised reasonable care in hiring the repairman, that the repairman was an independent contractor, and that public policy made a homeowner's duty to keep the sidewalk safe for pedestrian a non-delegable duty. If the pedestrian brings an action against the homeowner to recover damages for the injury caused to him by the repairman's negligence, will the pedestrian prevail? Yes, under the res ipsa loquitur doctrine. Yes, because the repairman's act was a breach of non-delegable duty owed by the homeowner to the pedestrian. No, because the repairman was an independent contractor rather than the homeowner servant. Or no, because the homeowner exercised reasonable care in hiring the repairman to do the repair. I think it's B. I might have done this question before or one similar.
It's
but I
definitely
think
between B and C, right?
Yeah, and I don't think that the fact that the repairman was an independent contractor makes a difference, because you can't delegate the duty. So I think it's B.
I'm with you. doing questions before is helpful because even if it's the same fact pattern or similar fact pattern, that's what you're going to see on the February exam. Very similar fact patterns that almost look the same because they're testing the same way. In general, an independent contractor is liable for zone torts. However, an exception exists where the contractor is carrying out an inherently dangerous activity or there's a public policy consideration that makes the duty non-delegable. The facts indicate the duty to make the sidewalk safe for pedestrians was a non-delegable duty. Right here. That was the key fact. I should have highlighted that. The public policy made a homeowner's duty to keep the sidewalk safe for pedestrians a non-delegable duty. That was the key to that question. It wasn't necessarily the proper answer unless we understood that piece. Is everyone cool with that? It wasn't because we did it before that we know that's the right answer. It was because it was a non-delegable duty, and therefore they're both going to be held liable. Where usually you wouldn't be held liable for the acts of an independent contractor. There's certain circumstances you would, inherently dangerous activity or public policy consideration that makes it non-delegable duty. They literally told us in the fact pattern. Good job, May. Oh, I should have done that one, but whatever. Let's do this one. Pablo.
Yes. As a shopper was leaving the supermarket, an automatic door that should have opened outward opened inward, restricting and breaking his shopper nose. The owner of the building had installed an automatic door. The lease percentage which the supermarket occupied the building, provided that the supermarket was responsible for all maintenance of the premise. The shopper sued the market. At the trial, neither the shopper nor the supermarket offered any testimony expected otherwise as to why the door had opened inward. At the close of evidences, both of the shopper and the supermarket would move the judgment as a matter of law. How should the trial judge rule? Okay. Grant judgment of the shopper because it's on dispute to the door malfunctioning. Grant judgment for the supermarket because the shopper failed to join the owner of the building as a defendant. Grant judgment of the supermarket because the shopper failed to offer proof of the supermarket negligence. Submit the case to jury because of this fact negligence may be inferred. See? Here, the best answer for me is D as in dog.
I agree with you. D as in dog, right? Let's submit this to the jury. Maybe we can infer some negligence here. Excellent. Based on the evidence in the record, the jury can infer negligence because the accidents occurred from a door in the exclusive control of the supermarket, and this is not the type of action that would occur without negligence. Either way, it's a question for the jury to decide, right? They're not required to decide that, but they strongly indicate that res ipsa could be the case here. D is correct. The jury may decide to infer negligence based on the evidence under res ipsa. Either the jury could decide to infer negligence by the supermarket or decline to do so. Either way, judgment as a matter of law is not proper for either party because a reasonable jury could come to either conclusion. Good stuff. That leads us to Sam. Do you mind reading this question?
Sure. A customer fell and injured himself when he slipped on a banana peel while shopping at a grocery store. The banana peel was fresh and unblemished, except for a mark made by the heel of the customer's shoe. In an action brought by the customer against the store, these are the only facts and evidence. Should the trial judge permit the case to go to the jury? No, because the customer had an obligation to watch where he stepped. No, because there is not a reasonable basis for inferring that the store knew or should have known of the banana peel. Yes, because it is more likely than not that the peel came from a banana offered for the sale by the grocer. And yes, because the store could foresee that a customer might slip on a banana peel. This one's a little tough.
Tough? No, it's not tough, and I'll tell you why. This
Why?
is a huge siren, fresh and unblemished. What does that mean? It means that it just dropped, right?
Yeah, sorry his iPad died, so he's a little upset.
No worry, buddy. You just learned some tort law. Fresh and unblemished. It just dropped. So what do you, now that I told you that, what do you think the answer is?
I realized that, but I guess I can't understand what difference does it make. I mean, in my head, my first instinct was that, they're supposed to watch to see if anything falls, if anything's gonna hit and hurt somebody, right?
Let me help you. You've been crushing it. I've been watching you, and I know you have a whole cast of characters at your house, a lot of kids to take care of. But you've been doing an amazing job, and I'm just going to add one more thing to your wheelhouse, which is if they tell you on the MBE something is fresh and unblemished, it means it just dropped, and there's no inference that they had a duty to know about it, right? Because it just dropped. They're not supposed to catch every banana as it drops. They're supposed to do reasonable sweeps, but this one just
Reasonable sweeps, yeah. Okay, I understand. So I think B, yes.
B is in basketball, yeah. Unlike slip and fall cases in which race is appropriate, the condition of the banana peel does not indicate that it's been in the ground for any significant period of time. Therefore, there's not enough evidence to support a jury verdict that the store staff was negligent in failing to remove it before the customer's fall. We're cool with that one? A lot of people got that one wrong. That's a common question that we get wrong, but we know that if it's fresh and unblemished, it just dropped, there's no reasonable basis. All right, we're back up to the top. Alita, you mind reading this one?
Sure. A man who was visiting a shooting range misunderstood a signal that indicated shooting in progress and walked in front of another customer who was shooting toward a target. The man was hit by a bullet and seriously injured. The man sued the customer, the owner of the range, and the manufacturer of the signaling apparatus. The jurisdiction prohibits a plaintiff from recovering against a defendant whose fault is less than or equal to that of the plaintiff. If the jury determines that the man was 25% responsible and that each defendant was also 25% responsible, will the man be able to recover damages, and if so, how much from each defendant? D.
Yeah, straight up from the information, right? D is in dog, right?
Yes.
I'm with you. Because it just said right in the thing, if they find that that they're less than or equal, then you are barred from recovery. Well, they're all 25%, so that's equal, barred from recovery. Sometimes it's just reading comprehension. Good, excellent. Let's try this one. Oh, I think this is one that has two answers. So there's a 50% chance of getting it right. If you mind reading this question.
Okay. A trucker driving down an isolated country road late one night struck cattle that had escaped from a farmer's pen and wandered into the road. The trucker was unable to stop before hitting the cattle, but was not driving carelessly. While he was not injured in the collision, the trucker sustained damage to the truck and lost income during the time it took to repair the truck. The trucker sued the farmer for his damages and invoked the doctrine of re ipsa loquitur. At trial, the farmer introduced evidence that his cattle pen was of a sufficient height to prevent cattle from stepping over it and was constructed of thick steel pipe sitting in concrete with a substantial top rail. A sturdy pen such as this one would be more difficult for cattle to break through than one constructed of barbed wire or electric wire. Should the trial court allow the case to go to the jury with a re ipsa loquitur instruction? A, no, because it is possible that a third party wrongfully let the cattle out of the pen. B, no, because the trucker must submit direct evidence of negligence in order to invoke the re ipsa loquitur doctrine. C, yes, because the farmer is strictly liable for harm caused by his escaping cattle. Or D, yes, because the jury could conclude that cattle would not ordinarily escape a strong, secure cattle pen in the absence of negligence. I do like D.
I think there's two answers to this question.
You like D?
I like D. Does everyone else like D? We're getting head shakes with D. I think we're going to see two answers to this question. Oh, no. This isn't the same.
Haha.
Right.
D.
The facts indicate that the farm was in exclusive control of the farm is a similar question with two answers. The facts indicate that the farm was in exclusive control of his farm and that the trucker did not contribute to the accident. Therefore, the jury is permitted to conclude that the cow escaped due to the farmer's negligence. It's not strict liability because it's not an abnormally dangerous activity. Even though it's possible a third party let the cattle out the pen, the farmer was in exclusive control of his farm and the trucker did not contribute to the accident.
Mm-hmm.
Good job. I was thinking of a different question. Grace, do you mind reading this question?
Yes. If the plaintiff asserts a claim for damages against the defendant based on trespass, which of the following would be the correct disposition of the case? A plaintiff owed a large tract of land on the shore of a lake. The defendant lived on a stream that ran along one boundary of the plaintiff's land and into the lake. At some time in the past, a channel had been cut across the plaintiff's land from the stream to the lake at a point some distance from the mouth of the stream. From where the defendant lived, the channel served as a convenient shortcut to the lake, erroneously believing that the channel was a public waterway. The defendant made frequent trips through the channel in his motorboat. His use of the channel caused no harm to the land through which it passed. Once the defendant learned of the plaintiff's ownership of the channel, he stopped using it as a shortcut. If plaintiff asserts a claim for damages against defendant based on trespass, which of the following would be a correct disposition of the case? Judge for the defendant. I think it's between A or B. She did not use the channel after learning of the plaintiff. Yeah, I think it's A.
I agree. It's trespass. It doesn't matter. You did it. Excellent. Trespass is intentional entry. You do not need to know that's a private property. And even if there's no damages, you could still get nominal damages based on the trespass alone. Excellent. Right on top of that. Doing really good. This part of class, we're doing really good. We're finishing strong, which I always tell people in life about like anything. If you run marathons or if you play a sport or if you're taking a test, you should always have that realization, like right now, 15 minutes left. Most people get fatigued at the end. That's when I try and tell myself, okay, wake up. This is the final stretch. Once you're finished, you can literally go to sleep or do whatever. But like, don't drag yourself through the finish line. That's where a lot of people, the difference between passing and failing. You did a great job for 2 hours and 45 minutes. And then the last 15 minutes, you kind of fall off. So that's just, I always tell people about that. I see it in sports a lot. I told you I like combat sports. In boxing, happens all the time where someone's doing great fight, and then at the end of the fight, they get tired and get knocked out. Same thing with us. Let's finish strong. So who just did that, Grace? Joe, do you mind reading this question?
Yeah. An 8-year-old child went to the grocery store with her mother. The child pushed the grocery cart while her mother put items into it. The child's mother remained near the child at all times. Another customer in the store noticed the child pushing the cart in a manner that caused the customer no concern. A short time later, the cart the child was pushing struck the customer in the knee, inflicting serious injury. If the customer brings an action based on negligence against the child, child's best argument in defense would be that A, the child exercised care commensurate with her age, intelligence, and experience. B, the child is not subject to tort liability. C, the child was subject to parental supervision. D, the customer assumed the risk that the child might hit the customer with the cart. I think it's C as the best, but I'm really not sure. I know D is not the right answer. I would eliminate that. A is not a very convincing argument, I don't think, for a best argument. But I'm not sure.
I like A over C actually. Let me see what people are saying in my chat. The chat's gone too big. Sorry. I'm getting some A's in the chat. Yeah, I think that's his best argument actually. I know you didn't like A, but let me explain what I think. That B is wrong. Children are subject to tort liability.
Yeah.
C is wrong. Go ahead.
So Andrew, I'm here a little bit confused before you continue, because now is the customer being action against the child, and the question is the child best argument in defense. That's why, in my opinion, this B will be so we have to make in consideration B, I believe, because they are talking about the child, so it's straight to the child.
Oh, D as in dog, yeah. Because they notice the child pushing the car in a manner that caused the customer no concern. I don't think so. They cause him no concern. I think
it's A, because A is standard for negligence for kids.
Right, and B is not a true statement. Children are subject to tort liability for their actions, and they're subject to it based on A. C, but we're not suing the parents. We're suing the kid. Just because you're under, I like A better. I see why you like C, but I like A better. And then assume the risk. I don't seem like there's any risk to assume. You could get this one wrong. It's about that time, right? No, not exactly time. A is correct. This choice gives a child-appropriate negligent standard of care. Exactly what you're saying, Grace. The customer's claim for negligence would be allowed, but the child will only be held to the standard of care expected of a reasonable child of the same age, training, maturity, experience, and intelligence. B is broad and not a defense. The child is not too young to be held liable for tort. Children as young as 4 have been capable of performing a tortious intent. C, the child's mother can assert supervision or child's defense against a claim for negligence and control of her daughter. I thought it was his son. But is not available for the child herself. They never say if this child is a boy or a girl. Why did they just assume it was a daughter? I mean, not that that's a bad thing. I'm just wondering. Okay, so we understand why A is a better answer than C. That's the defense for the mother that I was supervising the kid. The child's defense is I didn't do anything unreasonable. I was just pushing this cart around. I think that's fine. Who did that question?
Joe.
Joe. All right, May, do you mind doing this one?
What is likely to be the dispositive issue in this case? A man and his friend who were both adults went to a party. The man and the friend had many drinks at the party and became legally intoxicated. They decided to play a game of chance called Russian roulette using a gun loaded with 1 bullet. As part of the game, the man pointed the gun at the friend and, on her command, pulled the trigger. The man shot the friend in the shoulder. The friend has brought a negligence action against the man. Traditional defenses based on plaintiff's conduct apply. What is likely to be the dispositive issue in the case? Whether the game constituted a joint venture, whether the friend could validly consent to the game, whether the friend was also negligent, or whether the man was legally intoxicated when he began playing the game.
Tough question.
Yeah,
Tough.
this one's kind of hard.
I'm a little conflicted here. Anyone thoughts from the audience? What can we eliminate?
I feel like I think I might be leaning towards C. And maybe well, actually, yeah, no, like some kind of like comparative negligence
Isn't this
defense.
consent?
I would like B, yeah, because
They
I would
agreed to
be-
Russian roulette, which is
and they were both drunk and they both consented to playing a dangerous game.
And the man was legal. I just don't love B because why is that even an issue? He could not consent. He was drunk. Drunk people can't consent. You're legally intoxicated. I don't think that's an issue. I think that's
Well, then D would be the answer, no?
whether the man was legally intoxicated when he began playing the game. But it says he was legally intoxicated.
I think it's C because they talk about in the facts that traditional defenses based on plaintiff conduct apply. So
I still think it's
I almost am considering A here. Am I the only one who's looking at A, a joint venture? Like if they're acting in concert and it's
But isn't that criminal law?
no, like, well, not always. They went to a
Is that
party.
a tort though? Like, is that
Russian roulette using a gun with a bullet. You know what? I'm gonna be honest. I definitely done this question before, and I cannot remember what the answer is. So, I gotta think. Does anyone have a thought?
wait, isn't consent not a defense for negligence? Isn't that only for intentional torts?
Right.
So it's not B, I take it back.
it's
not-
Okay, I didn't know.
It's not B, right? We can't consent to being negligent.
Well, it's not a defense.
It's not a defense, yeah, that they consented to negligence.
I just realized that.
Whether the man was legally intoxicated, I feel like he was. That's not even an issue. They tell us he was. Whether the friend was also negligent.
And
The
C,
man and his friend had many drinks at the party and became intoxicated. They decided to play a game of chance called Russian roulette using a loaded gun. As part of the game, the man pointed the gun at his friend on a trigger. The man shot the friend in the shoulder.
if the friend is also negligent, that will impact the other person's damage. So I think that's the correct answer.
Yeah, you're right. Not joint venture. That'd be if I was thinking if someone else got injured by it, right? But it's the friend. So I kind of like C. Was that our original answer?
that was the reader's original answer. I don't know who the reader was.
Let's see before we decide to highlight the reader. Nice. Good job. Good job. And more people picked B. I'm the only idiot who was thinking A for a minute, but good thing I have my class. Contributory negligence is an appropriate action to a negligence action. And here both parties seem to have been acting unreasonably. Many states would now evaluate the defense under comparative negligence. B, what a lot of people were looking at, see, B was picked before in October, is likely that consent to this activity would be routinely found to be against public policy, although the consequences of determination would vary from state to state. But consent is a defense more appropriate raised in intentional torts, not a case for negligence. Whoever raised that, perfect point. There's
Yeah,
no-
because I thought that first, Emily, and then I reread it, and then I was like, oh no.
Exactly. Yeah. Good catch. It's all about catching. See, I caught myself too. We got the right answer. Excellent job. I think Sam had to probably take care of her kids. So Alita, it's actually gonna work out perfectly. Do you mind reading this one?
Sure. If the mother sues the television station for the invasion of her privacy and that of her son, will the mother be likely to prevail? A 15-year-old boy was killed during a gang fight. 2 days after his funeral, the boy's mother saw a television program about gang violence and was shocked to see video of herself weeping over the boy's body. The video had been shot by the television reporting team while the boy's body was still lying on a public street. The mother suffered severe emotional distress as a result of seeing the video. Will the mother be likely to prevail if she brings an invasion of privacy suit? No, because the person has no right to privacy after his or her death. I'm going to eliminate that one right off the bat. No, because the street was open to the public and the subject was newsworthy. Yes, because the mother did not get permission to have the video used in the program. Yes, because the mother suffered severe emotional distress as a result of viewing the video.
What?
Why did you highlight 2 days after his funeral?
Because, well, at first I thought it was going to be IIED or NIED, so I could actually unhighlight that. But then when I saw his invasion of privacy, now I'm more thinking about newsworthiness.
Yeah, but then it was also published by a television program about gang violence, not like even though it had been shot. I mean, by the television,
I think
which is the only thing that throws me off.
I think it's
Like-
just throwing you off for no reason. Like, it's television, it's news, it's a news channel about gang violence. You're weeping. Like, I could see it happening, you know? I'm out on the street. You shouldn't have been out on the street, but like, you know, it's like the guy who was cheating on his wife. Like, it sucks. It sucks that you're weeping in public, but I do think it's newsworthy. Anyone else like B?
I like B.
Yeah, this is going to be newsworthy, and newsworthy is going to be something that will, you know, prevent a successful invasion of privacy claim. B is correct. Liability for invasion of privacy. The details are not newsworthy. Here, the mother was weeping over the boy's body in the public street after a gang fight. The social value of this outweighs the invasion of privacy, and the mother will not likely be able to prevail. All right, I'm going to try and finish up. I only have a couple more, so let's do it quickly. In action by the gardener against the golfer to recover damages for harm to this plantings, what will the gardener be able to do? A gardener's backyard, which is landscaped with expensive flowers and shrubs, is adjacent to a golf course. While a golfer was playing on the golf course, a thunderstorm suddenly came up. As the golfer was returning to the clubhouse in his golf cart, lightning struck a tree on the course, and the tree began to fall in the golfer's direction. In order to avoid being hit by the tree, he deliberately steered his cart into the gardener's property, causing substantial damage to the gardener's expensive plantings. So Prevail, although occasioned by necessity, the entry onto the gardener's property was for the golfer's benefit. Prevail for nominal damages only because the golfer was privileged to enter the gardener's property. Not prevail because the lightning was an act of God. Not prevail because the golfer's entry on the garden was occasioned by necessity and therefore privileged. What do we think? It's to recover damages. It's not for trespass.
She can recover damages.
Okay, and is it going to be nominal or prevailing entirely?
It's not nominal.
Not nominal means prevailing entirely. I like that because this is right. You actually harmed it for your benefit.
Right, because you have the necessity, like it's a private necessity, so you can do it, but there's still going to be damages liable to the gardener for her plants.
Incomplete, right? Like incomplete meaning, yes, it's a privilege, but you still need to pay damages. You're not going to be, you know, known as a trespasser in the docket, but you still have to pay the damages.
Yeah, if it were public necessity, you wouldn't have to.
Exactly, but it was your own benefit, which made it private. In an action by a guest against a hotel to recover for injuries, what would be the most likely outcome? A hotel employed a carefully selected independent contractor to rebuild its swimming pool. The hotel continued to operate while the pool was being rebuilt. The contract between the hotel and the contractor required the contractor to indemnify the hotel for any liability arising from the contractor's negligent acts. A guest of the hotel fell into the excavation, which the contractor had negligently left unguarded. An action by the guest against the hotel to recover for injuries, what would be the most likely outcome? Liability because the hotel had a non-delegable duty to keep a safe premises. I don't hate that. Liability because contract between the hotel and the contractor required the contractor to indemnify the hotel for any liability arising from the contractor's negligent acts. No liability because the contractor was the actively negligent party. No liability because the hotel exercised reasonable care in employing the contractor.
I like A.
I like A too, by the way. I read it. I'm moving fast, and usually when I move fast, I get them wrong. But does everyone else like A? 2 A's? Pablo said A?
Yes, A.
All right, and May, thank you with the A. Ordinarily, someone who hires an independent contractor would not be vicariously liable. However, a landowner who owns his land open to the public has a non-delegable duty. Such landowner is liable for negligence. Right here, because they were a hotel, they had that non-delegable duty. Good job. A defendant operates a bank courier service that use armored trucks to transport money and securities. One of the defendant's armored trucks was parked illegally too close to a street intersection. The plaintiff, driving his car in excessive speed, skidded into the armored truck while trying to make a turn. So driver's excessive speed, defendants parked illegally. The truck was not damaged, but the plaintiff was injured. The plaintiff has brought an action against the defendant to recover damages for loss resulting from the accident. The jury determined that both parties were negligent, but the defendant was less negligent than the plaintiff. The jurisdiction follows pure comparative negligence. So in this action, the plaintiff should recover, right? The defendant was less negligent than the plaintiff. His entire loss reduced by a percentage that reflects the negligence attributed to the plaintiff. Right, because it's pure comparative negligence. Yeah, we like C's. From my quick understanding of the question and the answers, I like C because it's pure comparative negligence. Nice, not too fast. In pure comparative negligence, the plaintiff may recover his full amount of damages, less portion attributed to his own negligence. We talked about pure comparative negligence a few times. I think it's 2 more questions. A mother rushed his 8-year-old daughter to the emergency room at a local hospital after the child fell off her bicycle and hit her head on a sharp rock. The wound caused by the fall is extensive and bloody. If the mother sues the hospital, will she prevail? Mother rushed her 8-year-old to the emergency room after the child fell on a sharp rock. The wound caused by the fall was extensive and bloody. The mother was permitted to remain in the treatment room and held the child's hand while the emergency room physician cleaned and sutured the wound. During the procedure, the mother said that she was feeling faint and stood up to leave the room. While leaving the room, the mother fainted and in falling struck her head on a metal fixture that protruded from the emergency room wall. She sustained a serious injury as a consequence. Will the mother prevail against the hospital? Yes, because she's a public invitee. Yes, because the fixture is not an obvious, commonly used in a central part of the hospital's equipment. No, because there's no evidence that the hospital's personnel failed to take reasonable steps to anticipate and prevent the injury. I like C. No, because the hospital's personnel owe the mother no further duty of care. You do owe a duty of care, but here, a metal fixture protruding from the wall, that's normal, I think, in a hospital. Excellent. Good job, Pablo. The mother's status and invitee imposed a duty to warn of known dangers, but there's no evidence that they failed to use reasonable care in connection with the fixture, which was not hidden, and there was no indication that it posed a foreseeable defect. All right, let's hear about this firstborn child. Speaking of firstborn child, my dog is being firstborn, pain in my ass. All right, a firstborn child was examined as an infant by a doctor who is a specialist in the diagnosis of speech and hearing impairments. Although the doctor should have concluded that the infant was totally deaf due to a hereditary condition, the doctor negligently concluded that the infant's hearing was normal. After the diagnosis, but before they learned that the infant was in fact deaf, the parents conceived a second child who also suffered total deafness due to the hereditary condition. The parents claimed that they would not have conceived the second child, yikes, had they known of the high probability of the hereditary condition. They have sought the advice of their attorney regarding which negligent action the doctor is most likely to succeed. Which sort of action against the doctor should they succeed? All right, this is kind of easy for me. It's who's claiming it. The parents don't want the kid to have been born.
Then it's a wrongful birth.
Mm-hmm.
Got you.
Right, wrongful life is filed on the kid's behalf. Good job, M. Wrongful birth, because it's wrongful life is right. Wrongful birth is brought by the parents. Wrongful life is brought by the kids. Good job. I told you that was the last one. Would you know it? We did 25 questions. We got 25 correct. That's a pretty rare occurrence, but that's a testament to how great of a class you all are, because I definitely wouldn't have gotten them all correct myself. So excellent job, everyone. That's how, my 1 hours go. I work with my students. I always go a couple minutes over because I want to make sure, not always, but if necessary, to make sure we get 25 questions in. And I think it's super valuable. If we were to have missed any questions, we would have reviewed them and documented them. Today, we did miss a couple questions in the first 25, and then we missed a couple questions this morning. There's a couple missed questions we have out there that I'm going to put on a sheet to document so that we won't get them wrong on test day.